You've got multiple properties in California and only one living trust to hold them all. It sounds efficient, right? But here's the thing. Bundling everything into a single trust could expose you to legal risks, tax issues, or worse, blow up your entire estate plan down the line. I'm Ali Talai, estate planning and asset protection lawyer who founded Talai Law Offices. And in this video, we're unpacking when one trust works like a charm and when you need multiple trusts or LLCs to stay protected and in control. One of the questions I get asked often is, how many properties can I place inside of my revocable living trust? And the reality of it is, for most of us individuals, real estate investors, all we need is one revocable living trust. And that particular revocable living trust can hold multiple properties, multiple LLCs, and there are no restriction as far as how many properties we can place inside of this revocable living trust. Sometimes, depending on different factors, we may come up with a plan that has multiple trusts in there, and that is really driven by what we're trying to do. Are we doing more of an estate tax planning, asset protection planning, probate avoidance? And those could be factors that may require us to have multiple trusts. So how do you properly transfer your real estate into this trust? This is a key factor here. You could have an excellent trust if you still own your real estate under your personal name and you don't transfer them into your trust, and let's say unfortunately something happens to you, this trust is not going to do us a whole lot. There'll still be a great chance that we'll have to go to probate court and get the probate court involved and get some sort of order from the probate court that allows us to transfer the property into the trust. So funding your trust becomes essential. What do we use to transfer the property into your trust? We use a deed, a quitclaim deed, a grant deed. 3 main items must be on this deed. Well, there are lots of things that have to be on this deed, but when it comes to your trust, you want to make sure you have the name of your trust on the deed, and you also want to make sure you have the date when this trust was drafted on the deed. If you have a trust that was drafted years ago and since then you have amended the trust, restated the trust at different times and different dates, you only place the date when the trust was originally drafted. The fact that the trust was amended and restated multiple times, it matters, but when you're preparing a deed, those dates do not go on the deed itself. The date of the trust, it will always be the initial date when the trust was created. All right, so when one trust might not be enough, let's talk about that. I do a lot of planning for blended families, and in that kind of planning, there are more often we end up using more than one trust. A lot of times I have one trust for each spouse and they get to transfer their separate property in there, and they may have the need to have a different trustee at the time they pass away. They may not want their other spouse to be the trustee that would have control and management over their separate property. And then we usually do a joint trust for the spouses together, especially in cases where the spouses together have purchased properties or they have children together. So now in this scenario, we have 3 separate trusts. They're all revocable living trusts, different provisions with different trustees, with different assets that are being funded in this particular trust or the particular trust that the asset is going to. And so that is an example of when multiple trusts would make more sense. It would be more clear as far as the intent of each party. It is clear who gets to manage the assets if something happened, one spouse passes away. It is clear who gets to be the beneficiary of the trust. And so in that scenario, it is a much better idea to have multiple revocable living trusts than try to do the entire plan with just that one revocable trust. The other reason we may want to do more than just one trust, more than just one revocable trust, is that sometimes, depending on the total value of the estate and the goals that we have, we may need to use different kinds of trust. So revocable living trusts, these are excellent trusts. They help you avoid probate, and we could do incapacity planning. We could do asset protection planning for our children. At the time we've passed away, the inheritance that we're going to provide to them, it can go to them in such a way that is protected from future possible creditors that they may have. Those things can all be done with a revocable trust. But let's say you have a very large estate and we want to do some estate tax planning. At that point, we may want to do a special irrevocable trust that is designed to avoid estate taxes. Or let's say we want to put in some sort of an asset protection planning. And in that case, we may use another type of an irrevocable trust, another sort of planning like LLCs and holding LLCs. But for those reasons, an individual could have an estate plan that could have multiple trusts, multiple different types of trusts. All right, so let's briefly talk about the role of an LLC in your estate plan. Revocable living trust, the fact that you have the power to revoke this trust, it will not provide us any asset protection. And so for that reason, we may want to use an LLC, particularly if you have investment properties or if you have other assets that you want to make sure that you create some sort of structure that allows greater asset protection planning to be incorporated into the estate plan. And in that scenario, what we'll do is we'll create an LLC, have the property transferred into the LLC, and then have the LLC's membership interest, instead of that being owned by you, that would be owned by your trust. All right, so you may be asking, how about a use of a land trust? And land trusts are a very useful tool in estate planning, and we use them a lot of times when we're doing estate planning for real estate investors and individuals that have real estate, and we have the property, let's say they're investment property, transfer into the land trust initially, and then have the land trust beneficial interest assigned to an LLC, and then have that LLC maybe assigned to another holding LLC, or have it directly transferred and owned by the revocable living trust. That structure could provide us with a great deal of privacy. It could provide us with asset protection. And then also at the same time, something happens, the person passes away, we have a plan in place that it would avoid the probate process and the expense and the delay and all the stuff that goes along with that. All right, the other question that I get often is, well, how many LLCs do I need? If I have rental properties, do I place each single one in its own LLC, or do I bundle them up and put them all in one LLC or two LLC? How do I go about this whole thing? And this is a really tough question because it really depends on many different factors. If, let's say, money is not an issue, we're not concerned about any of the fees that it would be associated with setting him up and sort of paying the Secretary of State and all the upkeep, then ideally you would have each property in its own LLC. And the idea is that we want to separate our assets, separate our rental properties or investment. Because if we have one LLC, let's say, and you have all your rental properties in there, and now property number one, that the tenant files a lawsuit against the LLC, because we have all of our other properties inside of that same LLC, we're sort of exposing all the other properties to the lawsuit that is being brought by tenant from property number one. If that property is placed in its own LLC, then now if something happens in property number one, there's a lawsuit brought against that particular LLC, we have now protected all of our other real estate. And so it could provide us with a greater asset protection, but sometimes that just cannot be done. Imagine you bought a 10-unit apartment building. It's going into one LLC. You're not going to be able to put them into 10 separate LLCs. So it really depends on the value of the property. It depends on how much equity you have. It depends on how many properties you have. If you have 4 properties and something happens and you lose all 4 properties, that's a pretty big blow versus, let's say you had 40 properties and something happened and because of some sort of a lawsuit, you lost 4 of the properties, even though nobody wants to sort of lose 4 properties, but it's much more manageable because you still have 36 properties. So those are all factors that you want to keep in mind when you're trying to figure out, do I do one LLCs or multiple LLCs as you're putting your estate plan together? We covered how many living trusts or LLCs you need to protect your assets. But what about gifting them? Is it worth it to gift your assets? Check out this next video where I answer that exact question. See you over there.